All right, so welcome everybody to the Tenant and Landlord Townhall. This is the first of its kind that the United Way of Southeast Iowa has hosted. We have a lot of different experts up here to talk about different things regarding both tenants and landlords. On your seats, there are blank cards that you're able to write down any questions that you may have, or just take notes if you want to. There's also a potato and some other information regarding some different food insecurity and other campaigns that the United Way is currently doing. So feel free to take a gander at those. We will have a time at the end of the presentations for Q&A. So that's where if you want to write down questions as they come along, you can either pass them up to me and I will read them aloud, or you're welcome to approach the panel and ask them yourselves. All right. Without further ado, we'll just go around quickly and introduce everybody, and then we'll kind of get started. So I'll start down here.
Thank you very much. I'm Dan Feltis, managing attorney with Iowa Legal Aid, manage the Fair Housing Rights Project, and do eviction work and discrimination work. Also manage the Farm Worker Rights Project in Iowa Legal Aid.
Hi, I'm Annette Remick, and I do the Housing Choice Voucher, or better known as Section 8, for the City of Burlington.
I'm Caitlin Frizzy, and I handle the Section 8 Housing Choice Voucher for the rest of Des Moines County, all of Louisa, all of Henry, and parts of Lee County.
I'm Cheryl Bloom. I'm with Community Action. I'm the housing specialist and here to answer anything or services that Community Action can provide.
My name is Ashley Tim, and I work at Alliant Energy Company. I'm a workforce support coordinator. I work for the field engineering department, just doing construction assistance.
And I'm James Humphrey. I work for the City of Burlington. I'm a rental and nuisance inspector for the city.
Fantastic. So the first part of this, each one of our experts have prepared kind of a mini presentation regarding their specialty and expertise. So we'll kind of go through those, and again, as the questions arise or you have questions or comments, feel free to write them down, and then at the end of all of them, we'll have an open question and answer session. So I believe our first one is, that's the overview, is Dan with Housing Law.
Great. Well, again, Dan Feltis, Iowa Legal Aid. Iowa Legal Aid is a statewide nonprofit legal services law firm providing legal advice and representation to low to middle income families across the state, including here in Southeast Iowa. I operate out of the Iowa City office, but our Fair Housing Project is a statewide project, so go around the state doing different kinds of work. And so I'll go over Housing Law 101. You can probably spend 15 hours doing this, but I'll do it in 10 minutes.
Perfect.
All right, so next slide. So first and foremost, talk about leases. There are prohibited provisions in rental agreements, and this is the state law with respect to that. And you can see that, basically you can't put in your rental agreement to waive or forego basic rights that are in state law or in federal law. That's the key component. You can't put in your rental agreement that you agree to confess judgment on any potential future dispute. You can't put in your rental agreement that you're going to agree to pay for the other side's attorney's fees. American rules, everybody pays for themselves unless there's some specific statute that authorizes attorney's fees. Everybody pays for their own attorneys. There's also a prohibition on agreeing to exculpate or limit liability. What does that mean? That means basically, you're not going to have the other side agree. Tenants can't agree in a rental agreement that we're going to just say, all right, I'm going to cover all your costs if something bad happens, right? It's just not that's kind of common sense, but it's in the state law. Next slide. So what are some examples of prohibited lease agreements? Well, for example, legal lease terms in lease agreement, basically, if landlord can't deliver possession at a time agreed, tenant agrees to accept rent abatement and full settlement of all damages. Well, it sounds reasonable. Iowa Supreme Court says no, not so much. You got to deliver. If you're a landlord and you say, hey, this place is going to be available on X date, you got to make it available. If you don't make it available on X date, you can't just say, all right, well, why don't you just, I'll give you just a break on rent. So also automatic deductions from the rental deposit. You can't do that. We'll talk about rental deposit law a little bit more in a few slides. Next slide, more examples of illegal lease provisions, termination of lease for a single lease violation. That's not something that you can do. You have to provide, we'll talk a little bit more about this, but you have to provide a 7-day notice to cure of a lease. If you're a landlord, for example, and you believe that your tenant is violating the lease, you gotta provide a 7-day notice, say, hey, stop violating the lease. Then, after that 7 days, if that violation continues, well then, you can go forward with your eviction. But if you put in your rental agreement, hey, one violation, that's all that counts, and then you're out, well that's in violation of the state law, because the state law says give a 7-day notice to cure, and then if you're not curing, then you can go forward with the eviction. Another kind of situation is a crime-free lease addenda. Landlords and just everybody in general is reasonably concerned about public safety, but if you put in something that just de facto says that any kind of crime that happens on the premises results in you being evicted, well that's a problem. Why? Because that person may or may not be responsible for their criminal activity at all. And we'll talk more about this in a little bit, but including survivors of domestic and sexual violence. If there's criminal activity on the premises, if you're a survivor, you're not, hey, responsible for the conduct of these perpetrators of domestic violence. And so putting in a crime-free lease addendum may sound good on its face, may make common sense, but depending on how it's drafted, it could be a legal lease provision because it may automatically just basically say we're not going through with the state law on these provisions in terms of eviction. Indemnification, what is that? Well, that's an agreement to basically say, all right, landlord, we're going to cover all your costs no matter what happens. You can't put in that lease agreement. A late fee by another name still stinks. That's a nod to Romeo and Juliet. I didn't put that. This is a variation of this slide. That's not my joke, so I can't deliver it very well. But nevertheless, bottom line, late fees are not just agreeing de facto to a late fee, and then a late fee could be something that you could be evicted for. It's not lawful. Can you do late fees? Yes. But agreeing in a rental agreement that you can be evicted for late fees, no. See the distinction? Insurance, you can't put in there that if you're a landlord, you can't put in there that tenants have to buy a bunch of insurance. This happens more in the Des Moines rental market than it does, welcome. It happens more in the Des Moines rental market than it does down here, but you see that occasionally in Des Moines. Just a forced requirement that you have to buy all this kind of insurance and all this other stuff. That's not lawful under state law. Next slide. Other illegal lease fees, we talked about attorney's fees. Number 8, notices being deemed to be sufficient. If you are a landlord or if you work with your service providers, a lot of great people up here doing work with folks who are facing eviction in some cases, housing insecure. One of the biggest things that happens in eviction court is the notices are deficient. Either the timing of them or the explanation on them. You can't put in a lease agreement, hey, every notice that I provide you is sufficient. We've seen that a lot, and that's just an illegal lease provision. Section 8, can't do side payments. Yeah, a lot of people may know this. This is a violation of both state and federal law. There's something called the FMR, fair market rent. If you got a Section 8 voucher, you can move into certain places. Sometimes you can get a little bump on it. You can do a hardship waiver and bump up that rental amount of what's eligible to have a Section 8 voucher there. But sometimes landlords say, all right, I want to have a higher rent, and I'm above the federal market rent, so why don't we cut a side deal? And whether it's verbal or in writing, that's illegal. It's an illegal lease term too. Waiver, another concept. If a landlord, for example, gives you an eviction notice and you're a tenant, and then you pay the landlord rent, and the landlord accepts this and is a month to month, like, oh yeah, thanks for that rent. And it's after the expiration of a 7-day notice, and you accepted the rent, and there's a 7-day notice for a lease violation. Well, you probably waived your ability to go forward with your eviction because you created another month-to-month tenancy. But sometimes landlords put in the rental agreement, no waiver, no how, no situation, that's illegal. So these are some basic things that are illegal lease terms. Next slide. So we could go over this a lot, but I'm going to go over very briefly. Eviction, generally speaking, there's a 3-day notice for non-payment, and that's the cure period. You got to pay the rent within the 3 days. These are the baseline steps, the process of eviction. A 7-day notice for some other lease violation, and then a 30-day notice for lease termination or non-renewal. In other words, saying, hey, we're not going to renew your lease is up June 1, we're giving this to you on, I don't know, April 15th, that's at least 30 days. That would be a legitimate 30-day notice to say we're not renewing your lease. Then when the lease is up, or when the 3-day notice is up, or when the 7-day notice is up, you have to do a 3-day notice to quit. But you have to wait until those notices are up, right? You can't just do it within those 3, 7, or 30-day time frame. Then, doing an eviction, you file what's called a forcible entry detainer petition, so otherwise known as eviction. It's in small claims. You can file if you want. As a landlord, you can also file small claims contemporaneously for unpaid rent or whatever. But basically, you have to file in small claims. You have to file the FED petition, and typically the hearing's scheduled relatively quickly, within 10 days or so. Now, security deposit, that process, you can't charge, and I have the statutory site there, you can't charge more than 2 months rent for a security deposit. And then when people move out, by the way, you also can't commingle your rental deposits. If you're a landlord, you can't put it in your personal account. You got to put it in a separate account. You can't commingle. It's got to be an interest-bearing account. When a tenant moves out, the tenant must provide a forwarding address, and you as a landlord must provide a notice within 30 days to that tenant. That notice needs to specify if there are any withholdings. So let's say there's a big hole in the wall. Well, that would be beyond ordinary wear and tear. You can withhold for that, and then you have to provide a reasonable estimate of the cost to fix that hole in the wall, and that can be deducted from the security deposit, but it's got to be in writing, and it can't be anything more than ordinary wear and tear. A lot of times you see a bunch of stuff. It's like, all right, there's a scuff mark on the wall. Well, that's ordinary wear and tear, especially if somebody's been there for a long time, and it's going to be ordinary wear and tear. So you're replacing the pans on the stove. It's not ordinary wear and tear. People put pans on the stove. Some of the light bulbs are out. That stuff falls into the bucket of ordinary wear and tear. And obviously it's like a spectrum. Like those are easily ordinary wear and tear. A hole in the wall is easily not ordinary wear and tear. Sometimes there's this dispute in the middle. What isn't a dispute is if you are a landlord and you don't provide this 30-day notice, you're SOL. And I mean that by, well, you know what SOL means. We'll go to the next slide. Fair housing. Again, we do seminars on fair housing. You can talk a lot about fair housing, but basically I'm going to hit the main points on fair housing. Next slide. So what are the basic fair housing laws? You go back to 1866. There's a law protecting people in housing based on race. The first Civil Rights Act in Iowa in 1965 predated the Fair Housing Act, and provided for protections in housing, public accommodations, and the Fair Housing Act came into existence in 1968, 2 weeks after the assassination of Dr. Martin Luther King Jr. The protected people and protected classes based on race, national origin, religion, color, and sex, which means gender. And then in 1988, there was some amendments to the Federal Fair Housing Act, including familial status, which means the presence or absence of children under the age of 18 or pregnancy. Presence of absence of children under the age of 18 or pregnancy, and then also disability. Next slide. So, does that mean you're automatically protected from any kind of bad situation in housing if you're a member of that protected class? Well, let's do an example. Dan calls the landlord, that's me, inquiring about an apartment for rent. During the call, Dan mentions he's a lawyer. I'm sorry, the landlord says, I just don't rent to lawyers. I don't like them. Has the landlord violated fair housing laws?
Click the button again.
No, I'm not a member of a protected class. The fair housing laws are meant to deal with historical problems market that people faced, going all the way back, no Irish rent here, no, so on and so forth. Lawyers have historically had a leg up on the situations out there, so they're not protected. Next slide. We talked about who is protected a little bit, but these are basically the protected classes. Again, it doesn't de facto mean that you're protected against any bad situation in housing: race, color, religion, creed, sex, national origin, familial status, disability, and in Iowa, sexual orientation. There was gender identity that was removed this year by the legislature and the governor. Next slide. Next scenario, talk about it. Bobby, who's black, speaks to the landlord about leasing an apartment. On the phone, the landlord's eager to rent to Bobby. But when Bobby meets the landlord in person, the landlord sees him. Landlord says, "Oh, you're probably one of those people who has a voucher too." A few days later, Bobby receives a letter saying his application was denied because of a negative landlord reference from his current landlord. Bobby's surprised, never had any problem with his current landlord, and his landlord swears he was never contacted for a reference. Has this landlord violated federal fair housing laws? Yes, probably. It appears discriminating based on race. Now, all of these things are fact specific. And again, just like we talked about with security deposit, some things are pretty clear on one end, some things are pretty clear on the other end. This is probably leaning more this way, but it's not super clear. It's probably leaning more this way based on the facts. So that's an example of a rental application that may have been denied. It appears to have been denied because Bobby's black. Next slide. So what are the situations in which this could apply? Again, membership of a protected class is not de facto protection. So refusal to rent, we just had a scenario on that. Refusal to sell, misrepresenting availability, differential terms and conditions. We have a case right now. We're talking about clear, fairly clear. This property management company told our client that because she's a single mom, she's a greater security risk, so she needs 3 months rent up front because she's a single mom. That's more on this end of the spectrum than on this. Some cases are in between. The cases in between are the ones that go to trial. The ones over here, that probably won't even go to trial. That's going to be probably settled. But different terms, conditions, and privileges. I want to highlight a couple key things on this slide. Advertising name preference, limitation, or discrimination, that means statements as well. So I want to be very clear about this. I mean, it used to be, you would see rental advertisements, hey, no Irish apply. Statement cases involve actual statements to tenants, and it includes statements not just by the property owner, but by anybody vicariously liable to them. In other words, they're employees. So maintenance personnel who are just joking around, making a joke they think is funny, but is not, that can incur fair housing liability. Okay? It's very important. Any statements in connection, you may not deny housing, but you make a statement that's, you can get fair housing liability. Just scooting ahead here, talked about domestic violence survivors. There's also a state law that says if you as a landlord take any adverse action in response to any call for law enforcement, that's prohibited and unlawful. That's not just a fair housing violation, that's a state law violation. It's meant to protect survivors in housing so that they actually can feel free to call the police rather than a landlord saying, hey, the police have been here too much. That happens a lot. I've had a couple cases right here in Burlington, evictions based on police calls. It's not lawful. Obviously, if it's a police call unrelated to domestic violence, it would be a different situation. But if you're summoning law enforcement for a lawful purpose, for your protection, and a landlord gets grumpy about it and wants to do an eviction, the other tenants complain, the police are here all the time, I'm so mad about it, and the landlord responds, that's not lawful. Next slide. And obviously you can talk about all this stuff a lot. Elaine, last scenario. Elaine has severe anxiety. Her landlord has a no pets policy. We see this one a lot. You probably have seen this kind of thing. Psychiatrist provides a letter supporting her need for emotional support animals to alleviate the symptoms of her severe anxiety. She presents this letter to her landlord and says, hey, make an exception to the no pets policy. Landlord says, absolutely not, no way, we don't have pets here. Is the landlord liable?
No.
Go ahead and, well, without more information, yes, because what Elaine presented was a reasonable accommodation request. And so the way that the law views this, and this is kind of a controversial area, but the way that the law views this is that if you have a provider that says you need an emotional support animal, and that animal actually does alleviate the symptoms of your mental health, well then it's basically akin to a prescription, like prescribing Prozac or lorazepam or whatever. It helps you use and enjoy the housing by alleviating the symptoms of your mental health. And so if you have documentation and you present it and the landlord says, no way, I'm not even going to talk with you about this, that's going to be a problem for the landlord. That's a rejection of a reasonable accommodation request. Next slide. So this comes up in the context of potentially evictions. Fair housing defenses can be defenses in an eviction process.
I've got a question you didn't answer.
We're gonna save the questions for last. We're gonna whip through here. Write down your questions. Sorry, but we're gonna whip through and then questions at the end. Okay? I'll answer it. But we're gonna do it. I'm gonna try to keep moving. Eviction defenses. If there's a fair housing, if somebody's evicted, for example, let's go back to the police example. Too many police calls. Well, you have a potential defense to that eviction. You could also file an affirmative complaint. There's complaints at the Iowa Civil Rights Commission. It has to be filed within 300 days. You can file a complaint with HUD, United States Department of Urban Development. That must be within 1 year. And then also you can file a civil action in court, and that has to be state court or federal court within 2 years. And those are your recourse. Again, you still have a recourse as an affirmative defense to an eviction as well if it happens in that context. And that is my presentation. I guess there's one more slide. Which says basically, I'm not liable for legal advice. Thank you.
Thank you very much. All right. So that was Dan. I think there's maybe. There you go. Perfect. That was Dan from Iowa Legal Aid. The next section that we're going to go into is with Annette and Caitlin talking about Section 8 and the local housing authority and some of the voucher programs. So take it away, ladies.
Well, most people know that Katie and I both, our wait lists are typically closed. We only open them when we can serve the people in a reasonable amount of time. They do typically move their transients a lot of times where they just, phone numbers, addresses are no longer working. So I just had my wait list open. When it's open, anybody's able to come in and apply. And then we also have outreaches. Cheryl is one, mowing, building bridges. And they have our applications on file to be able to help with case management when they're doing that. When they bring the applications back, they need to bring photo IDs, social security cards, birth certificates, proof of income. And those we processed and allow them to get on the wait list at that time.
So once they get on the wait list, that's where it kind of gets a little tricky with us. As much as we'd love to go through our wait list as quickly as we can, obviously funds are not there for us to do that. So we try to take in, as many applicants we can per month through our waiting list, but again, we're limited. So right now my waiting list is closed, but I have my application through my 4 counties with a couple outreach places, and I am slowly getting through my wait list. Actually, I'm at a faster speed now than I have been, so that's a good thing. Anyway, so once they get on the waiting list, we do what's called a preference and a non-preference. So we kind of have the same preference and non-preference. So elderly, disabled, local families get more of a preference than single, non-elderly, out-of-state families do when they apply. Once they hit their waiting list, then they go through an approval process. So we run some background checks, we ensure that they have an income source, make sure they don't have an eviction from another housing authority, of non-payment of rent, or,
It's called debts owed.
yeah,
And that's a HUD mandate as far as if they owe another housing authority money, they need to be on a current pay agreement with them. That's a form they sign with every renewal with us.
so, if they have that, they can either show us proof that they have set up a payment agreement, or show us proof that they paid off their debt with, past housing authority. So, anyway, so then it goes into when they, receive their voucher, so vouchers and that
Yeah.
process.
Once they get their voucher, they come in, they do a briefing where we go over the expectations, the roles and responsibilities, what the family obligations are. At that point, I typically give them what's called a request for tenancy approval. And then I also give them a landlord list, and I send them out to start finding a place. Here lately in Burlington, it's been extremely difficult. That's why my wait list hadn't been open for a while, just because people are having difficulty. Katie's not experiencing that on her end because she serves more of the outlying counties. And then once they get the request for tenancy back to us, we set up the inspection, we run the numbers and make sure that it's going to be rent reasonable. If that's the case, I send out the inspector, we share the same inspector, he works 2 days for each of us. And he goes and inspects it, and at that point, if everything's going to work, we go ahead and lease them up and get the HAP contract issued with the landlord.
They're in the unit, they start receiving assistance from our agency. The only time really, we need much from a landlord is if something's going wrong. We aren't there as much as a landlord is. So what our best thing that we always say is communication with our landlords is huge. Our landlord's letting us know, hey, they've got unauthorized individuals, they've got, criminal activity, or,
Not paying their rent.
they're behind on their
portions,
rent.
'cause we wouldn't know that otherwise.
Yep, or they're behind on their utilities, because most of the time, if they're behind on utilities, a client will typically call the homeowner. So, that communication from them, from landlords to us is, it helps us be in the know of what's kind of going on too. A couple things once they get on the program, the rent, will change if their income changes, whether they get income, they lose income. So, that's, we call that like an amended, interim adjustment on our end. And then, another thing, landlords, is extended absences from the unit, because we hear this way more than we should. Oh yeah, they've been out of the unit for over a month, and we don't know that. Or, yeah, they're in Mexico for 2 months with their family. I mean, for someone who needs assistance to be out of their unit for that long, we're not paying for a storage unit. So that is kind of where we, the communication from our landlords is huge. Sorry, I'm bouncing all over. So going back to when they receive their Section 8, make sure that they're paying their landlord their portion on time, allowing the inspector, whether that's the city inspector, I've got a couple county inspectors and our inspector, to do their annual inspections to ensure that they're, decent, their unit's decent, safe, and sanitary. And we always communicate that with the landlord. If our inspector sees something, we are always communicating that with the landlord, just so they know what's going on in their household too. So, again, we're here to help you guys and help them. So, what else am I missing?
Just during that first year, the rent
Oh.
cannot be raised, it's a HAP contract. After that first year, they can raise the rent, but it still has to fall under rent reasonableness. Sometimes landlords get a little excited after that first year and think they can increase it substantially, and that's not the case. It still has to fall within the standards. We are required to do that. So, a lot of times those are difficult conversations, but most landlords will see that they're not going to get that money otherwise. pay utility reimbursement to utility companies. I pay mine to the utility companies. Katie pays them to the individual tenant.
Yeah.
That's only if they're extremely low income, then we will also pay a portion of the utilities.
Yeah, mine actually is made out to both Tenant and Alliant or wherever that they can only, it can only be deposited for their utilities. So kind of gives them a little bit of a restriction. They can't just go cash a check and use it on, what they want. So a couple things, when they're on the program, anytime that their income changes, they're to notify our office. We also have a system that can catch when their income changes, and if it's not reported to our office in a timely manner, we typically send a letter out, hey, your income changed, you need to let us know, and that's when we would do it in an interim adjustment is what we call it in our office. So, couple things, when it comes to like a termination of a voucher, what causes that? It's obviously a violation of their lease. So non-payment of rent, non-payment of utilities, they have people living there who should not be living there, criminal activity. Those are just the main cases we see. Obviously, each household has a different situation, and sometimes we know about it, sometimes we don't. That's just unfortunately how it goes. But we do try to catch as much as we possibly can. We run criminals at each of their renewals, so if they have, committed a crime from September 24 to September 25, when their renewal comes around in August, we typically do them 30, 60 days before, we usually would see that when we run their name. So, and then just a couple things that we typed up for like our landlords. I'll let you kind of go with that, right? Oh, okay. So, Annette has a few printouts that we'll give some landlords too. So to start with, our housing authority and the landlord. The first thing we always ask for is a request for tenancy approval. Typically, it's kind of hard for me because I do cover such a wide area. I typically mail that. Sometimes I mail that to my tenant to get signed, or sometimes I do have, I mail it straight to a landlord and then we get the tenant's signature. So kind of situation by situation. I'm not exactly sure how you do that.
I usually give it out at the briefing, so that way they can hit the ground running with it. And most of the landlords that I work with know, they've seen them enough. I have great landlords, thank you for coming. And but I work closely with the landlords. I email them out for them. They fill out the front, they tell us what the utilities are, who's responsible, how they're powered, what the security deposit is, what the rent amount is, the type of unit, the year it was built, and we go into Des Moines County GIS and we compare all of that and make sure that they are actually the property owner, and then all of it assesses the way they say it does. And then on the second page, they tell me about other units they have and what kind of rent they are getting for those, so that's another way to ensure rent reasonableness. And then both the landlord and the tenant sign those and give them back to me.
So once that happens, typically the landlord will get in touch with our office and we'll schedule an inspection to make sure it's going to pass for our program. At that point, we make sure there's no issues with the unit or anything that needs addressed. At that point is when we will issue a HAP contract. That HAP contract kind of does the same thing the request for tenancy does. It just labels out what is what. It has who's in the household, the lease dates from start, to end, who pays for what utilities, and that is signed between our office and the landlord. So, and that states, no raising the rent for that first contract year. It kind of goes into like who's responsible,
And
between tenant and landlord.
correct.
So.
And we also have to have the lease, and it has to match up with the HAP contract. And the HAP contract does supersede the lease. I know a lot of landlords will try to lease out mid-month, and if we don't do it that way, I don't catch it, we won't. They've got to match. So that's always a tricky one to kind of maneuver and communicate back and forth and get done, but for the most part, it's a great program. We wish we could serve more families. My average half that I pay for a family is around $558. Other families, I pay much more, many much less. But just when rents continue to climb and our pot of money doesn't climb, we are restricted on how many we can help. And it's very frustrating, but we just try to help as many as we can. And after 1 year, they can take their voucher, they can port out to another community, they can go wherever. If they wanna go to the sunny beaches of Miami, they can go down there. And we pay indefinitely if that housing authority is not willing to absorb them. There's a lot of talk with NARO about trying to get some legislation on that so that there's a time limit, kind of like the 1 year half contract, but at this time there is not.
Someday. The other thing, kind of more on the landlord, just maintenance of the property, ensuring it's a decent, safe, and sanitary unit for our tenants. Again, keeping us in the loop if there's any violation or any issue going on. And then keep letting us know, hey, I see this quite often. Oh, I forgot to tell you, I don't have that bank anymore, but I made that deposit for them. Letting us know that kind of stuff, the more vertical side of things.
Or if they sell the property.
Or yeah,
Let us know that
yeah.
too, please.
And then a couple other things, letting us know, hey, I'm serving them an eviction, or hey, they're getting a 30-day termination. Again, just letting us kind of be in the loop so we're not sitting out in outfield when they no longer live in this unit, we're still paying for them. So, I have great landlords, I'm very lucky, and build a great relationship with all my landlords, and I have great tenants too. My whole goal is just to help families, as much as I can with as little as I have. So, Annette and I work a lot together. We work with the Fort Madison Housing Authority and the Keokuk Housing Authority, and I go all the way up to the WISA. So I deal a lot with the Muscatine Housing Authority. So, being able to reach out to other housing authorities and see how they do it has really been, wonderful to know, hey, this is kind of what we're seeing, kind of what you're seeing, and unfortunately everybody's seeing the same thing. A lot of help needed and not enough money. So, like Annette said, we're trying to do as much as we can and help as many families as we can. And if anybody as a landlord doesn't have a Section 8 but ever has questions, feel free to reach out to Annette and I. We're more than happy to walk you guys through the process, kind of let you know how we do things. Like I said, Annette's got some handouts, so we can hand those out at the end. And if anyone has any questions, we will get those at the end.
All right, so our next mini presentation is going to be with Cheryl from Community Action and Ashley from Alliant Energy. And there are some slides that accompany that as well. So I'll let you two take it away. I'm gonna move our camera.
You go first, yeah, okay. My name is Ashley, as Megan said, and I've been at Alliant Energy Company for 10 years. I worked at AT&T for 10 years before that, and then I worked at American Energy for 10 years before that. I'm hoping to break that 10-year mark, be there for a while. There are instances where our customers need energy assistance, they need some help with their bills, and we always provide them with a number for community action. They do have extensions and payment arrangements they can set up. We do let the landlords know that although they may have like what's called a landlord agreement, that only kicks in if a tenant is moving out. It's called a leave on agreement. So we have a tenant moving out, the services, the utility services would go into the landlord's name. But many of our landlords are under the impression sometimes that if it's disconnected for non-payment, it'll go on their name. So we want to make sure that they always are aware of that. We do provide energy efficiency programs to reduce costs, and we prefer community action for some assistance if that comes in. So I'll let you finish that rest of that slide.
For what? So we administer all the light heap applications and the weatherization applications. So if a household does call in, Obviously, there's income limitations, so if somebody comes in and they're just struggling to pay bills in general, we do an intake and we distinguish, okay, are you current with your rent? How much do you owe on rent? Are you current with your utilities? And we try to pair them up with whatever services that we have available. We have light heat that runs from October to April 30th. We then have a crisis mode that we go into after utility assistance or light heat, and that helps with disconnects to try and get them somewhat stable till energy assistance comes the next year around. Weatherization, if we have a senior citizen or something that does own a home or rents a home based on their energy usage, they could qualify for weatherization of their home, which is updating a non-energy efficient furnace, or caulking windows, putting new caulking around a door, just the weatherization team will go out, do an energy audit, that sort of thing, to figure out ways of making a home more energy efficient. People go, oh, well, I want to be eligible for that program. The unfortunate thing is that program, we serve 4 counties, so we get to help probably 10 to 15 households in calendar year. So even though you qualify for that program every year, based on your LIHEAP application, it might take a while for you to get up that weatherization. It's all dependent on usage, and the weatherization team in the state, they decide who's eligible for that. But anytime you have a tenant that is struggling to pay rent or struggling with utilities, your first referral should be, you need to call community action.
So this just covers a community action day that Alliant Energy does in Washington DC. We can you go back one? We attend Washington DC, and we partner with Edison Electric Institute, and just really to present information from Alliant Energy on how important it is to continue LIHEAP funding. I think now more than ever, we have a lot of people out there that are struggling to pay their bills. So we do want to have a unified front that demonstrates how important this energy assistance program is to the community, and it does represent the values of Alliant Energy, and we want to continue to have customer affordability and have all those elements available to our customers. This one just kind of goes over the process that we just went over previously. We refer people to community action. Homeowners and renters are eligible if they're within specific guidelines, and those guidelines change.
They change every year.
Yeah. So as was stated, the applications are first come, first served basis. It starts October 1st for people who are 60 and over and who may be disabled. The last income guideline I had was for 200% of the poverty guidelines. You have to be responsible for the energy bill, or if it's included in the rent, I believe that you still may be eligible for assistance.
Yeah, there's always a way to see if we can get somebody eligible. Usually if it's in a landlord's name, as long as the landlord hands us a bill that has the address and an account number, we can apply the energy assistance to that bill. But we just have to cross our T's and dot our I's. So even if the utilities might not be in their name, we will tell them what they need to get eligible for that assistance.
Yeah, I mean, community action does a really great job on trying to help customers get as much assistance as they can. Sometimes, you really have to do some backflips to get there, but they work with people. They do such a great job. If you're not eligible for LIHEAP, you may be eligible for other emergency funds in the state, and these come and go, and sometimes it's difficult to predict. There might be crisis assistance, reconnection if you've been disconnected assistance. Sometimes there's other monies available with community action. You also could be eligible for payment
website. So that's got the income restriction, so if ever you wanna know if one of your tenants or whatever, it has the household size and then it has the annual gross income. But again, we know the rules and we know how to bend the rules, so if if an annual snapshot, they're not eligible, we can break it down to a 30-day snapshot and figure out a way, you know, sometimes people are seasonal workers and that, you know, we would wanna pick a time where their income showed that. So we have the flexibility of doing a 30-day, monthly income snapshot or an annual. So sometimes it's just best to say, you need to call community action.
So this is for payment arrangements and extensions. So an extension is just simply extending your current bill date up to 30 days. It doesn't extend any bills that come out after that bill. It's available to residential and business customers, and the extension needs to be set up before the due date of that bill. If you're on automatic pay, if you know you're gonna have some financial difficulty, please call and cancel your auto pay and set up this extension before it's due. You also could be eligible for a payment arrangement. This is more of a long-term, we take the balance that's on your account and you extend it over several months. A lot of times people will ask you, how much can you afford extra to pay each month? When I went to Mid-American, it was 12 months. You can pay it off early. There was in the winter months, something called a renegotiated payment arrangement, where if you did the extension for 30 days, and then you still haven't been able to pay, and then you set up a payment arrangement, if that payment arrangement didn't work out, or if you defaulted on it, you may be eligible for another one in the winter months, because that's when we really essentially we wanna give you on and offer you another option. So just keep that in mind if you do have a large bill, or if you know anybody that does, that they may be eligible for a payment arrangement. Do you have anything you want to add?
And we just, like I said, we get, Hometown Cares, Mid-American will give us extra pots of money, Access Energy, so usually if we get somebody, we will rob Peter to pay Paul to, you know, we have the flexibility to use the funds on any way we see fit to keep a household going.
You can go to the next slide, maybe. So this was, I wanted to put this in here, important notes on arrangement. So if you're on a payment arrangement or extension, don't mail in your payment. If it gets lost or it takes a while, then you could put it off on that arrangement. You wanna call in, or we can refer you to someplace that you can pay in close, quickly. We cannot accept in-person payments. So if you come to our offices, which typically most of these offices like in Burlington, we're just kind of a remote site. It's really a construction office where we have crews that work out of there. We're doing new construction, those types of things. So you wanna just contact us for community action as soon as you know that you're gonna have a bill that's past due, because there may be something that we can do for you or community action can do for you. If we do disconnect your service, we cannot guarantee a same-day reconnection except in the months November 1st through April 1st due to those extreme temperatures. Arrangements can differ during the winter months, which I touched on. You can go to the next slide. Another way that we can help you with your balance or bill or to save money, there are some weatherization programs that are available to some customers, and this is something that community action can speak to as well. If you qualify, you can have somebody visit your home and make some energy efficiency updates free of charge. Do you have anything else on that?
I kind of touched on that, we always get calls, I wanna be in that weatherization. If you are LIHEAP approved, your name is automatically in that hat for that program. The state and our weatherization team go through the list of use, so we get a usage list, and the top households that use the most consumption, those are the ones that they target first. Like I said, they can help maybe 15 to 20 households with weatherization, and maybe 10 to 15 furnace replacements, depending on what furnaces are. And so it's a very good program. It's just, like I said, we can't help the number of people that are on our list. exciting program when you're dealing with a senior citizen that gets a new furnace out of the deal, so.
Yeah, that's amazing when you can have
Yeah.
those stories to share. The Hometown Care Energy Fund, something that you touched on as well. It's supported by funds from Alliant Energy shareholders, as well as, employees of Alliant Energy, retirees, and customers. There are some options up there on how to make a payment or to donate. This is a great program. They do a lot of help. I'm hoping that we get a lot more money poured into Hometown Care this year because it's definitely needed. This is, I think I touched on already, it's just the landlord and tenant. We work with a lot of landlords. We sometimes have really interesting discussions with landlords. We are not gonna just connect electricity so you can get your tenant out. If you tell us that's what you're doing, or climb up and just connect something, please don't do that. We want to be fair, but we're there to provide a service, and we recommend landlords, if they have those types of issues, that they take the proper steps legally to take care of that situation. We do try to let landlords know if their property is in danger of being disconnected, mostly just because we're not trying to tell the tenant's business or information, but we want to protect their property, and we don't want to, especially during the winter months, turn off electricity and gas and have pipes freeze, because then there's a huge expense for the property owner, and the tenant also is in a bad situation as well if they're living there still. So once again, if we do contact the landlord, it is very, very vague. We just let them know that their property, it's 123 Main Street, is subject to disconnect for non-payment. So that is all we share with them. So this is a program called Powerhouse. It's actually like a TV YouTube program. It's kind of fun. It's a couple that talk about ways to save money. They give you, there's tips of the month. They let you know some ways to save money. They talk about energy efficient light bulbs and thermostats and all different kinds of ways that you can make changes in your home. All this information is available on energy.com. So check that out. And this one's kind of neat. There's online at onlineenergy.com. There's a safe how to the appliance calculator. So you can just pop in appliances. There's check marks, so you can go through and you can actually calculate different appliances or several appliances and how many kilowatt hours they use. It talks about making updates to your home, so you can turn things off all at once if you're home, if you're living home for an extended period of time. There's also information about rebates. They vary. I was going to put them all here, but it is a lot of information. It depends on the type of furnace. Also, sometimes if you're turning in an old appliances, you may be eligible for a rebate, so keep that in mind. Yeah, I just included this to check out alliantenergy.com to save. There's a marketplace where you can get instant rebates on power strips, air purifiers, thermostats. Gives you smart hours. There's also it used to be called Summer Saver, but it's a device that you can use. Are you familiar with that, Megan?
Yeah.
Yeah, it's a device you can use like in the summer hours specifically, where you're cycling your air unit, your central air on and off during peak hours. Now, it's not an extended amount of time, and I don't recommend it if you have a medical condition like asthma, but keep it in mind, it can save money and you get a nice little rebate on your bill as well.
Fantastic. Cheryl, do you have anything left to add?
Did you put my, those documents that I?
All of the documents that you handed are over there for folks to grab. Yeah.
So my actual duties is the housing specialist for community action. I dabble in the interview assistance just because the housing part is so time consuming. But anybody that's homeless or in jeopardy of homeless can reach out to me, and I can get them on a statewide homeless prevention priority list for our region. And my funds are to help relocate somebody that's experiencing homelessness or trying to help a household stabilize until they can get accepted for a Section 8 application, that sort of thing. I do case management with the households that I deal with. We work on budgeting, we work on getting jobs, we work on how do I cut my utility bill, how do I get school FAFSA application submitted. I mean, my case management, I deal with them for 3 months, 6 months, 9 months. I have a year program. It's just whether or not I can get you approved for federal funds. So I included landlord lists because this was gonna be a landlord and how to fill properties and that sort of thing. I don't include everybody on our landlords, just ones that I know wanna participate. So if there's a landlord that ever wants to be added to my list, all I gotta do is that, and I try to update it once a year. I try to educate people when they call in and they are struggling, you know, hey, you're not in a rent reasonable, you know, you're a household of 2, you're only eligible for a 1 bedroom, you should be, you know. So there is also a rent reasonable breakdown for all the counties that we serve. So it will tell you what a rent reasonable rent and utility mark for all the Des Moines counties for 1 bedroom, 2 bedroom, 3 bedrooms, all the way to Henry County, that sort of thing. So I do a lot of education with clients when they're like, well, it was cheaper than the last place I lived at. Still not rent reasonable, so you would not qualify for rent assistance funds through any of our programs. A lot of that education is kind of what we lack probably in this region, and probably our biggest obstacle. I try to educate as many people as I can that, hey, you need to get into something that's more rent reasonable for your household, because once you get to the voucher stage, that housing is not gonna be accepted. So getting the applications filled out and just educating them on, okay, you need to be looking at an income-based property, you need to be looking at these properties. These are landlords that you can probably target. They have a little bit looser guidelines on background and that sort of thing. So my position was a COVID position. It was designed out of COVID. I helped Iowa Rent and Utility Assistance Program disperse rents, that sort of thing. My funding is about over, so April 30th I might be out of a job. So we don't know if it's something that's going to be, you know, put through to the next administration. So, but anytime you have a tenant struggling with housing, struggling with paying bills, their first call should be community action.
Absolutely. All right, so our final mini presentation before questions is going to be James, who is a city inspector.
So my name is James Humphrey. I work for the city of Burlington. I do rental inspections and also do nuisance inspections for the city of Burlington. I have kind of a short little slide show here to show you guys, and I'll answer any questions I can afterwards. So what we do is rental inspections. They are following our Chapter 161 of the Burlington Housing Code. It also goes along with the 2021 International Residential Code and the 2021 Building Code, which that kind of primarily, the International Building Code primarily is with that for the multi-unit type inspections. When an inspection is complete, basically the landlord and tenant, if tenant violations exist, have a total of 60 days to make those repairs and corrections. Our process as well is we set up a re-inspection date with the landlord within 30 days of that initial inspection. We do that primarily because, say they have a laundry list of things that need to be fixed. We set the re-inspection date, we come out, maybe they fixed a good number of them but missed a few. They still have additional time within that 60-day time frame to make those repairs, allowing them to be in compliance. A permit is issued once the repairs and corrections have been made, and they are required to be renewed every 3 years. We originally had a 5-year cycle. Beginning of last year, we switched over to a 3-year renewal cycle for all units, multis and single-family homes. Section 16109 of the Burlington Housing Code, that deals with responsibilities of occupants relating to the maintenance and occupancy of premises. That has a litany of things that it goes over. Two examples up there would be, the upkeep, the cleanliness of an apartment, as you can see on the right. And then, like smoke detectors, those need to be in there, can't remove those, and things in that nature. There's quite a bit. I'm gonna go over all of them, but I can answer questions as needed. Responsibilities of owners relating to the maintenance of occupancy of premises, that is covered in 16108 of our Burlington Housing Code. A couple examples there that you might see on the board, an outlet that has just been screwed into a stud with bare electrical conductors being exposed. I've seen that one when I first started, and the one next to it is basically not great. It's some live electrical wires that are not in junction boxes and that are wired very haphazardly. We also deal with rental housing complaints. We do get those from time to time. Complaints must be filled out by the current tenant and submitted online, in person, or via mail. Once we have those complaints filed, sent in to us, one of the three code inspectors, myself, Matt, or Carly, will be reaching out to the tenant to set up a time to come out and investigate the complaint. Say your say there's an issue where your supply facility, say HVAC system goes out and it's the middle of winter and your heat's not working. We would go out, see what's going on with the system, see, we're not there to fix it, but we're there to investigate and see what is the issue. What can we do with our housing code to make sure that the landlord makes the repairs to get that unit back up and running to get you your supply facility. There's other things that rental complaints also fall in with as far as our housing code goes. If a violation is found, the code inspector will post orders to the property and send orders to the property owner via certified mail. And once again, these orders are 60-day orders. As much as we would like them to be taken care of initially as fast as possible, they do have that 60-day to get in compliance for those orders. Generally, what we like to do is stay in contact with the tenant to see if things are being remediated. If they aren't, it just kind of gets us an idea of how things are progressing. Hopefully we're progressing to a positive outcome, and whatever the issue that we had to issue the orders over have been complied with. And if not, it just kind of keeps us, kind of lets us know what our next steps might be. Once again, repairs must be completed within that 60 days. If repairs are not completed, a notice of denial or revocation in order to vacate will be issued. And hopefully we don't get to that point, but sometimes we do. And then as far as that goes, again, here's our contact information, myself, Matt Hamill, one of the other code inspectors, and Carly Dunbar, our city's website, and also we have some links to rental housing. I tried to print out the minimal structure standards for dwellings and the tenant and landlord responsibilities from our city page. However, the way they print it out, I think, is a little difficult to read, so if somebody would like a copy of that, I can try my best to get you a little bit better copy. So, and I also have copies of rental complaints if anybody needs those. And then, yeah.
So we will now begin some of our question and answers, and so I'm going to go around and collect your papers if you have them, but I'll start off with a question we got on our Facebook, and this might be a tag team between James and Dan. So, what is the best way to deal with landlords who will not fix obvious issues or violations and continue to use pressure to kick people out, and or tenants who say they will stop paying rent until issues are fixed?
Well, I can answer part of that. There at times when we have rental complaints, there has been tenants who do fear retaliation, as unfortunate it may be. And what I always tell the tenant on my end, if you feel that you have legal issues as far as you feel retaliation or something in those regards, I always tell them your best option is to seek legal representation, whether it be seeking out local representation, Iowa legal aid, because tenants do have rights. And our then if there are things that aren't being fixed, we have to go after those landlords to make sure that those issues are being taken care of, and if not, then they're not going to be able to use the property as a rental property. As simple as that on our end.
I agree with what James said. Just add, it's important as a tenant to, if your landlord's not rectifying things, to reach out to the city of Burlington, and to do it in writing, to make sure that you have a written complaint, because sometimes landlords, you should do it to your landlord first, give your landlord an opportunity, and do it in writing to the landlord. And then the landlord doesn't do something, then you do a written complaint to the code office, and keep track of it, keep those receipts, because sometimes there'll be complaints about issues that are unresolved, and the landlord will say, no, I didn't get that. Well, keep track of that stuff. And then if you're in eviction court, for example, if there's an eviction that comes after you complained, the judge is going to know, if you have it in writing, that you complained, and complain to James's office. And hopefully you have it in writing. So number one, let me do everything James said, but also keep copies of what you're doing. And you know what? It's important for the landlord too to have that documentation, but you want to keep your documentation. In terms of that's eviction and retaliatory eviction. So there's a rebuttable presumption in the law that, like, let's say, hey, there's no heat, I complain, landlord doesn't fix it, I have it in writing. Then I complain to James. James, you have it in writing. Then the landlord issues an eviction, non-lease renewal. Well, I guess you get a non-lease renewal 5 days after complaining about not having heat. The judge is going to look at that if you have the documentation and conclude, in all likelihood, that's a retaliatory eviction for complaining about basic, fundamental housing rights. Two other things on this. One is the rent withholding, what was mentioned. You gotta give, the law is very clear. You have to give it in writing and give your landlord a shot before you rent withhold. If you're starting to rent withhold right away, it's bad news. And so give the landlord a shot, a reasonable shot, provided in writing before you do that. The law also provides that you can do a diminution in value type of small claims. So for essential services, it says essential services in the statute. So if you provide in writing, let's say, hey, fix this, they don't fix it, send a note to the city, reaches out, still not fixing it. Let's say it's heat, for example, which is a basic one that no one can dispute as essential services. And let's say the landlord's responsible for heat, and that's an essential service. Well, you can then do a more offensive, not defensive, defendant and eviction, more offensive. Hey, these essential services are not being provided. I calculate the diminution in rental value to be half of a month's rent for each one, and I'm going to seek that from a judge. Now, there may also be additional rights too. They might want to reach out to Section 8 if it's part of the HAP contract in particular as well. So, in all situations though, I know things happen informally, you want to maintain relationships, tenant and landlord, but on situations like that, especially if it's a pretty significant repair issue, put it in writing. I know people get grumpy if they see something in writing, but put it in writing. Say, look, I just need to put this down. Please fix the heater. Please fix that. And then if they don't, then send it to James, escalate it, and then if you have that stuff in writing, you'll at least be protected in a retaliatory eviction sense. But a little tricky on the rent withholding, and then also you have some other options too.
And I'd also caveat once again to say, we have in the past received rental complaints from tenants that no longer occupy the unit anymore. They're no longer living in the dwelling. We are not able to then go inside the unit at that point because once again, they're no longer a tenant. So if you are having these issues, I would say if your landlord's not able to, if you're not getting the outcome from the landlord that needs to happen, please reach out to us because when when you're no longer living in the dwelling, it's just not fun. We're not able to get in there and take a look at it unless a current complaint come in for that unit.
So kind of a follow up to that, how do you know what is a tenant responsibility to fix and maintain versus a landlord responsibility to fix and maintain? Well, it could be, yeah, I'm sorry. I'm just looking in this general direction.
Well, I mean, there are supplied facilities, and minimal housing standards, those are covered in our code. If anybody has questions as far as what is their responsibility, what is the landlord's responsibility, I always direct people, if they can give me they say, hey, my stove doesn't work. Well, it's a supplied facility, it has to work. However, by code, the Burlington Housing Code, it just has to have space for a stove. So the landlord could remove it and they'll be known as a landlord who, I guess, doesn't have a stove in their apartment. But it's there's certain things that are their responsibility. So say we go and do an inspection and the tenant has not taken any of the garbage out, that kind of deal. They have all sorts of stuff rubbed on the wall, any sorts, there's lots of things in those regard. Those would then fall under that tenant responsibility. But as far as you have HVAC system, it's a supplied facility. It has to be there. It has to function. Those type of things. If you have no water pressure, once again, supplied facility, it does have to work. Once again, through the nature of the rental complaints we get, what we normally will do through our process is see what the complaints are ahead of time, kind of run it through our housing code to see where it lines up, and then proceed that way. Sometimes when we go out to the rental inspections and we're looking at the unit, say, for example, somebody didn't have power in their unit, we get down to the basement, the breaker panel had been removed, and somehow or another the main drain for the apartment broke and the sewer was discharging onto the breaker panel. There are things that can escalate to be an emergency vacate because they are so life-threatening that a continuance of living in that unit could cause life safety issues. And also, once again, if we go in a unit, say there's missing smoke detectors, we do take notes of those because those need to be in there as well. So if anybody has any questions as far as what their responsibilities are as far as our housing code goes, I always get them to reach out to us because there's numerous ones. Once again, we have like print out, and there's also the links in our, but we on our end, we always want to have a very proactive relationship with the public and as far as tenants, and if they have questions, we always encourage them to reach out to us because we're here to make sure that the safety of the buildings ensures the safety of the tenant, and that's the ultimate goal because that's what we're here for.
Yeah, I'll just add, James called it supply facility, but another way you can look at it is basically fixture lock. It's part of the actual structure, windows, whatever. That's pretty clear. Plumbing, that's pretty clearly owner, right? And then there's a whole host of things that are kind of in the middle, but you want to look at the responsibilities with the code, with the housing code, owner responsibilities and tenant responsibilities. You also want to look at the state law, which defines essential services. So essential services need to be provided or not obstructed. Then also there's different responsibilities for who pays for different things. And this is where it gets a little funky. Like, for example, it may be a tenant accepted responsibility to pay for electric, and then next thing you know, electric's off. You might get this call like, hey, did you disconnect? And actually, no, there was maybe work being done on the building, or and something inadvertently, or the breaker box somehow, whatever. If the structure is affected by the conduct of the owner or just is faulty, that's owner responsibility, right? And so even if the tenant is agreed to pay for the electric, so that's kind of the general breakout, but it's a lot of, some of the stuff is going to be case by case, but some of the basic stuff, windows, refrigeration services covered in the code. Refrigeration is owner stuff like that. So it kind of depends, but, you know, on the situation, but that's the basics.
Yes.
Yes. You wanna do communication and you're saying what the owner's responsibilities and the tenant. So when I do a move-in, I have a room by room that lists the smoke detectors, the fire extinguishers, the CO2s. I have them sign it on the day to move in. Then, 3 months later, they're having trouble paying rent. Serve them a 3-day notice, okay? Then they pay some, and the next thing I know, I'm getting a call from the city saying, or not a call, but a notice saying, there's no working smoke detectors. So they go there, and they find 4 missing detectors, and I'm required to replace them in order to keep the rental permit, okay? So I do that. I don't understand if I were to provide that on the day of their move-in, how am I responsible for having to replace those?
Well, you as a property owner has to provide life
I
safety.
can't hear you, I'm sorry.
So you're fine. As a property owner, you're required to provide life safety, and those things, unfortunately, if they are removed, those are things that is a better conversation between you and the tenant. We are there to make sure that they are there, and if they're not, we don't try to guess if they're there or they're not there. Sometimes we've been in apartments and there has not been. We look for where a smoke detector could have been. We've never, maybe they were installed, they were forgotten about. We don't know. But what the outcome that we want is for them to be there. So if you're having an issue with a tenant that might be taking them down, that really, on our end, would fall into the lease. We just are requiring that they are up there.
So I would have to keep replacing them in order to keep the rental permit, is what you're saying?
I mean,
Even though I have a document stating how many there are, which location they're at, and they're signed by the tenant and the date.
right. So
Okay,
once
I
again,
just wanna make sure I'm understanding what you're saying.
okay.
Okay.
I think an easy way to phrase that is that the city has a relationship with the landlord, but the city doesn't have any kind of relationship with the tenant, right? So the city doesn't have an enforcement mechanism to go to the tenant and say, you have to do this, you have to do that. The city's contract, by permit, is with the landlord.
Okay.
Yeah.
I've seen people put their, excuse me, their their smoke detectors behind the cage, so people can't get to them and tamper them, but the air can still go in. Does that make sense?
Mm-hmm.
And that way they can't pull them off the wall or tamper with them or whatnot.
I've been putting 10-year ones up,
Yeah.
so they can't take the damn batteries out.
Right.
And they still take them out of the ceiling, off the wall.
Now, from a legal perspective, if your property had a fire and the tenant had removed all the smoke detectors, who's liable?
She had proof that she's liable.
Like the responsibility on health and safety falls with the owner, but I think James is right, and Chad's right too, that there's nothing to stop you from saying potentially damaging items in the apartment, including removing smoke detectors, can be a lease violation. And
Okay.
there's nothing, I've seen that a lot of times, so,
Can she deduct it from the deposit?
yeah, that's
Well,
being an ordinary where it's.
I'm not gonna wait till.
That's deductible.
I'm
I've seen it
gonna
deducted.
send them an invoice and they got 5 days to pay it.
I've seen it deducted from deposits too, so.
I wouldn't wait that long.
Yeah, no.
If they took them down and I've gotta spend $100 and some to replace them, they're gonna get an invoice. They are not cheap,
No,
okay?
no.
Especially those 10-year ones.
And then-
I mean, is there, well, never mind. I'll
Yeah,
ask
I would just say, whether it's smoke detectors or other damage that you send invoices to tenants for, whether it's smoke detectors or whatever that you send invoices to tenants for, that's not considered rent, that's a
Correct.
charge.
Right,
And a charge, just like a late fee, generally is not something to evict. You can do a small claims for that amount, and you can continue to bill them, but generally speaking, it's not a basis to evict. The basis to evict would be sending a 7-day notice saying, you know, hey, you need to stop taking down smoke detectors. And, you know, we have evidence of this happening, it's in your lease, you can't take them down. And then, after that 7 days, if it happens again, then that might be potentially a basis to evict. But the basis to evict is not the down payment of an invoice for the damage. Does that make sense?
no.
Well, that's the law. But, I mean, so basically.
I would ask
you
my
can-
attorney about that,
Yeah,
because
well,
if
right.
you send somebody an invoice and it says due within 5 days, 10 days, 15 days, whatever, the monies that you collect from that person goes to whatever outstanding balance they have
Correct.
first. Okay, so if they owe $400 rent and they've got $60 worth of invoice for the smoke detectors per se, okay? When they give you $360 towards the rent, you take the $60 of their invoice, now they pay $300 towards their rent.
Yeah, well, most magistrates aren't gonna go along with that in the eviction context. If you can evict for non-payment of rent.
Rent, right.
Correct. So even if you credit the rental payment
Well,
to
then I
the
take the
outstanding
60
charge,
and give them the
but then
300 back.
I'm just saying, most magistrates aren't gonna, you might have a lawyer that
I do.
can get some magistrates to do something like this, but most magistrates are not gonna say, all right, rent was paid and it was accredited to an outstanding invoice for damage, so therefore, we think we're gonna do a 3-day notice on the unpaid rent because I credited the rent to the damage, and we're gonna call it something else. Most magistrates are gonna be like, no, I see what you did here, and that's not. So my point is this, you can evict for non-payment of rent. You can't evict for the non-payment of an invoice for something other than rent. That's a general rule. But James, Chad, or I, you can try to work this out. You can do a 7-day notice saying, hey, I got evidence that you've removed smoke detectors, don't do it again. If you do it again, boom, you look at the 7-day notice, right? That's a different, I'm not here to give you advice on how to evict people. But,
That's what I have an attorney for.
yeah, right, but that's my point, and, that's the answer to those questions.
Okay.
Fantastic. Any other questions for that? Yeah.
I've got a few questions, but hopefully they're short.
Sure.
So Dan, for you, first of all.
Yeah.
You said no auto deductions on deposits. What about rent?
Unpaid rent can be deducted from deposit.
Okay.
Yep.
And you said about the crime and the police being
Yeah.
there and stuff. Can you put in your, lease agreement, if police are called to your address, that the landlord needs to be notified? Or fire, or that I'd like to be notified if the
Yeah.
police are called there?
Yeah,
Yeah, okay, so that's okay to do.
that would be okay to do.
Okay.
But, right, yeah, that would be okay.
But I
to
can't
do.
evict them
Yeah.
if they're, yeah, okay,
Right,
I get
yeah.
that. So insurance, you said you can't tell them they have to get a lot of insurances, but can I say that I require them to get renter's insurance?
No.
No. Okay.
Yeah, and I think that,
Yeah, I do
that's
tell
the
them.
indemnity, that's the, if you go back to the one, you don't have to pick a little slide, but it talks about indemnifying and
Yeah.
exculpating. It hasn't been, to be clear, that's what the clear language of the legislature says.
Okay.
And also to be clear, the Iowa Supreme Court has not, specifically said in terms of rental insurance
That they have to.
that they, one way or another.
Okay.
But that's obviously indemnification, that's exculpation, that's insurance. Now, you have
So
some
you
landlords.
cannot require that as well.
Correct,
Okay.
correct, yep. There is one attorney out of the Des Moines area that represents property management companies that says, I understand what you're saying, but I don't read the language that way. I read it as allowing us to require, but that's few and far between.
I do explain that my insurance only covers the building, and if they want
Yeah.
any of their stuff
Well,
insured.
that's good
That's
too.
common, that's
Yeah.
common,
Recommended.
though,
Yeah.
I mean, that's.
That's,
Yeah,
Yeah.
I
that's
highly
just a
recommend.
recommendation.
Yeah,
Yeah.
I could recommend it.
Oh, my stepfather wanted me to ask.
Sure.
It may take a while. No, I'm just kidding. He wants to know if you can say that he wants to rent only to seniors.
No.
That's discrimination.
So, there's a long answer to that. But the bottom line is that you should probably avoid that.
Yeah.
But that's a short answer. The long answer is senior citizens are much less likely to have kids, and that can be construed as familial status discrimination against families, basically. So, so you might want to steer clear of saying that and doing that. You would still, I said earlier that on the one end of the spectrum you have like, this is pretty clearly this, and this is pretty clearly that. This is more right here, but it's not like a slam dunk familial status discrimination. But that's what you want to follow, because if you're saying only rent to senior citizens, you're basically saying I'm not renting to families, and that's family status discrimination. So you should just avoid it. I mean, you might be able to wiggle out it and be like, no, I never really said no kids. I really like seniors.
Because his argument was how some of these facilities only rent to seniors.
There is an there are exemptions under the Federal Fair Housing Act for 55 and older housing. It has to be Section 202 funded by the federal government. But there's not, unless you're getting Section 202 funding, senior funding by HUD, you're not falling in that bucket, right? So if you're just renting, you can't do that. So
Okay.
you're gonna run afoul of family status discrimination.
Okay. And my last one for you is, with the security deposit and them giving a forwarding address.
Yeah.
I mean, I've had lots of times where the tenants move out, I never get a forwarding address, I never hear from them. How do I typically, they don't get a deposit back, but if they did, what do you do?
Well, the best way to protect yourself as a landlord is to follow the state law. The last known address is the address where they're renting with you.
Yeah.
And a lot of people, even though they won't give you a forwarding address directly, will do with the post office a forwarding address. So just send it, just to protect yourself in abundance of caution, send it
To
just
the
to that
post-
same address.
Oh, okay.
And it will get forwarded. If it doesn't get forwarded, tough luck, because you sent it to the last known address.
Okay.
And then keep documentation that you did. So.
Okay. Does anybody else want to go? I've got a few now for the girls.
Yeah, do you want to go for, go ahead.
Mine's also for you, Dan. For the automatic deductions from the security deposit, can you charge a non-refundable security or pet deposit? Can the landlord?
You can charge a pet deposit, if the pet deposit is construed as being part of the 200. So if you do the 2 months, right? So let's say your monthly, just a basic example. Let's say your monthly rent is $750. You can charge no more than 2 months rent as a rental deposit. So most landlords don't do that. They don't charge $1,500 and $750. They don't charge $2,250 at the jump, because you're not gonna. Who has that kind of money laying around? Well, people that are renting. But you can charge the pet. Let's say you're only doing $750. You're only doing 1 month's rent. You can do a pet deposit if it's within that gap of the next set, $750. You see what I'm saying? Second thing is you can't charge a pet deposit. So under that situation, under state law, you can get away with a pet deposit, basically. But you can't charge a pet deposit. You can't. The law is this black letter law. This is over here. to someone who needs it for a disability-related reason. So if you're charging a pet deposit, generally speaking, but that person needs the animal as an emotional support animal or a service animal, you can't charge a pet deposit because the law treats that as akin to you charging someone for being disabled. Like earlier I said that these animals are basically functionally a prescription. That's how the law views it. It would be akin to basically saying, all right, you have prescription for Prozac or lorazepam, you gotta pay me a deposit of $200 for having that there. That being said, so you can't charge for the emotional support animal pet deposit for that situation. You can, on the back end, deduct beyond ordinary reason wear and tear. So let's say the animal, albeit an emotional support animal, ripped off, chewed off the siding of some wall or whatever. The tenant can't say that was an emotional support animal, therefore you can't deduct from the rental deposit. You can. So damages as a result of the animal, even if it's an emotional support animal, can be deducted.
But you can't be a non-refundable deposit because like most places that at the end of it you gotta clean the floors and you know it's gonna be about $300. So can you charge a non-refundable pet deposit of $300 up
No.
front?
Yeah, it's considered within the deposit structure.
Okay.
So,
I may have seen this wrong, but you don't have to serve a 3-day notice to quit after the 3-day non-payment, right?
No.
It's just for after the 7-day and the 30-day.
correct.
Okay.
Yeah.
I think I just saw it wrong. And then for the repairs, like when the tenant leaves, can the like the hole in the wall, can the landlord, like how do they estimate that cost to deduct the security deposit? Can it be, does he have to get like a professional opinion or can they just estimate it or themselves?
I mean, ideally you would want some backup. You don't necessarily have to have like a third party come in and then provide an estimate. However, if you have done repaired holes in the wall previously and you have, like, oh, I know based on prior experience it's gonna be $150 to patch this hole or whatever. You wanna have some basis for it. And that's what the law requires. You don't have to have actually done it and have the cost. And the law does not require you to have a third party estimate, but you have to have some basis or documentation for it.
Can you charge for your own labor if you do it?
Yeah, everybody, yeah, that's part of it, yeah, but it's gotta be what this says is reasonable, so, I mean, whatever that means.
Can you put in the lease agreement, like, if there's broken light bulbs, X amount of dollars, if there's cleaning of the stove, X amount of dollars, with a reasonable amount?
Well, that might potentially run afoul of a illegal lease term, because the state law, again, any lease term that conflicts with the state law can be an illegal lease term. And the state law says anything, you only can withhold or deduct anything beyond reasonable ordinary wear and tear. So,
Okay.
so ordinary wear and tear, light bulbs go out. Ordinary wear and tear, the stove gets messy. Ordinary wear and tear, there's some scuffs here and there. Holes in the wall, not ordinary wear and tear, right? If there's a removal of the smoke detector, that's not something that anybody would consider ordinary wear and tear. So if you put that in the lease that, hey, we're gonna clean your stove, we're gonna deduct it, you might be running afoul of that illegal, that prohibition against lease terms that conflict with state law.
And I just wanted to ask a question on his question
Yeah.
about the animals. For the emotional support animals or whatnot, they have to have a doctor or somebody write something? Can they
Technically,
just say,
no.
"This is-"
Technically, no. The example I provided, somebody did, because I wanted to make it a clearer example. But under federal law, under the Federal Fair Housing Act, all that has to happen is somebody has to articulate to you a disability-related need. So they could say, look, I need an animal, I need a dog, I have anxiety, the dog helps me. That would be considered, under federal law, the Federal Fair Housing Act, a reasonable accommodation request right there. And the worst thing you could do as a landlord is not respond or to flat out reject it, because that would immediately be considered a denial of a reasonable accommodation request is immediately considered discrimination under the Federal Fair Housing Act. So let's stop there and then look at state law. State law has required that you do have to have a form filled out under state law. Federal law does not require that form, okay? The form basically says, you can go to the Civil Rights Commission website, it basically says, it's like, hey, I treat this person, check yes. This person needs a dog for emotional support reasons, check yes. And then they sign it, and they have to provide it. So, but that's just state law. And I think one of the confusions that arise out of that is that landlord's like, oh, well, I know about this form with the state, so I'm fine because you never gave me a form. But federal law doesn't require a form, and federal law trumps. So I think what unfortunate consequence of that was that it has confused everybody about whether or not the form is required. Last thing on this, and I know we have a question over there, but probably a follow up on this. Last thing on that is that if a tenant comes and says, look, I have a disability, I have anxiety, I need a dog, can you put a waiver in for no pets, or can you allow me to have a dog? You can, as a landlord, if you think you need backup, you can say, can you provide some backup documentation of that? You can say that. So you can ask for basically a letter. But be very, very careful, because the law says you cannot inquire into the nature or extent of the disability.
Okay.
Right? And it's a big difference here. It may seem like a distinction without a difference, but it isn't. Like, hey, can you give me a letter from your doctor? And you just say that.
Yeah.
But if you say, well, tell me more about your anxiety,
Why do you need it?
that's bad, right? You don't want to do that. So you can say, hey, just give me a letter from your doctor and we're all set.
Can you require like a certificate of shots and current with shots and all that good stuff?
Yep. So I don't know, James or Chad might know, but not only can you up to date on shots as any other animal, you can if there's licensing in the city of Burlington. Some towns and cities require like a dog license. If that's a standard requirement in the city of Burlington, well, then you can require that too. Like, show me the dog license, show me the shots, show me all that kind of stuff. You can do that too. And also, every now and then we'll get calls too about how far do you stretch this in terms of like damage. We'll tell tenants like, no, your dog caused damage, they can deduct. Doesn't matter if it's an emotional support animal. Sometimes tenants will call and be like, hey, I don't think I can take my dog out to an area to defecate, to poop in the it's like, no, you gotta figure out a way to do that. That's like basic stuff. So the basic stuff, vaccinations, license, all have to be taken care of. Another thing that can happen here is your insurance carrier for your property might say, well, some breeds you can't have here. Watch out for that, because that's a dicey situation. There are memos and case law on this that may not be a valid excuse to deny the dog. So you need it has to be a case-by-case situation. So you might have an insurance carrier that says no pit bulls, for example. That's a common one, whatever. We're not going to insure the property without pit bulls, with pit bulls. Your emotional support animal in a particular tenant, first of all, not every dog is purebred anything these days. So, especially rescue dogs, especially dogs that may even look like a pit bull. So, watch out, your tenant, that's a common situation. And the other thing is, it has to be fact by fact. specific. So the dog may or may not be dangerous. I mean, in fact, I've met some dogs that look like they may be completely pit bulls who are the nicest dogs in the world, and some dogs that look really nice that are not. And so the law recognizes that. The law is pretty tough on insurance carriers, and then you by extension, if you're a landlord, relying on the insurance carrier. So just be careful about that situation too.
We do have another question really fast before we go back for our Section 8 and low housing ladies. Your rental inspector who comes out, either him or you, do you check to make sure the property has an active rental permit?
I mean, typically, I guess that's more to you.
Yeah, I go on GIS,
Yeah.
I make sure that the owner is actually the owner, the assessor's information matches, but as far as asking for an actual rental permit, no, I do not.
Okay, so then follow up to that. What happens if you are a tenant and you file a complaint with the city, and then it comes to find out that you are living in a non-permitted rental property?
As far as that goes, we have a process where they have to basically apply for the rental permit and go through the inspection process. That is not something that we do track illegal rentals and go after illegal rentals for our housing code, but I believe I've only had it happen to me once in my time here. I was able to work with the property owners to make sure that the property passed inspection, all the deficiencies were taken care of, and they were able to get that, they were able to be permitted. At the same point, there are additional fees when there is an illegally occupied unit, and those fees depend on if it's a single family, a duplex, a multi, if that would ever pop up, which is not too often because generally a multi is, you see a house with 4 doors and, anyway, just those deals. If we get a complaint on that, then we have the issue of the complaint and also the rental inspection, and hopefully by way of combination, going through that together, working with the tenant to make sure those issues are resolved, working with the property owner to make sure that they become in compliance with our city's code, the issues can be complied with. So I would also say if anybody in town has a question on a property that they're looking at as far as does it have an active rental permit, please reach out to us. I mean, we can at least verify that that property does have a rental permit and that it's valid. Any other additional type information, they would probably have to file a freedom of information request to get as far as inspection details and that kind of thing. But we are able to say yes or no. And then as far as our guidelines for what in Burlington is required to have a rental permit is on our city website. It has a much better explanation than what I'm probably getting ready to give. Basically it's what it boils down to is a non-owner occupied home. So say a situation arises, you somehow know that you wound up with a family member's house, you own the house, but you don't live there, you're letting a cousin or a family member, or, somebody live there, whether or not they're exchanging any form of payment for rent, that does not apply to what, for us on our end, basically it boils down to non-owner occupied. So when we are dealing with things and say we do a nuisance case and we're checking information and we see that these certain things don't line up, and we look into it further and we can kind of validate those other discrepancies, we go after it at that point for them to come into compliance, figure out what is going on. Sometimes a property owner has a house that's vacant and nobody's living there, and at that point it's not required to have a rental permit. But occupied, non-owner occupied home is pretty much boils down in code, will have to have a rental permit. And yes, like you said, we have had rental complaints. It's not too often that have had a situations arise where we get a rental complaint and we show up and we're like, yeah, this property does not in fact have a rental permit, and we start our process to get for the outcome for them to be in compliance. ultimately, in situations like that, if the property owner can comply and start working on that, it is not our goal to displace a tenant that is living in a home. That is not the outcome. If the property owner is working compliance, making sure those issues are taken care of, that is the ultimate goal.
All right. Question?
Am I correct, Dan, when you say, because I was looking up here for the Iowa code for the service and emotional support animals? And so the Iowa code doesn't matter? We have to adhere to the federal only? I was confused
I would
on.
say, yeah.
Because the reason I was asking is because it says on here that the Iowa law allows for you to ask for documentation, and also, you can deny based on reasonable accommodations.
Okay, well, I don't, let me be clear, you gotta adhere to both Iowa law and federal law, and city of Burlington law, you gotta adhere to all of them, so.
To all three of them?
Absolutely.
Okay.
So my point is simply that, under the Iowa Fair Housing Act, basically, the legislature has provided that you, in an emotional support animal situation, that a form be filled out by the tenant. Like, they've expressly said, tenants, you need to do this, right?
Okay.
That doesn't mean that if a tenant comes to you and says, hey, I have an emotional support need, or whatever, I have anxiety and I need a dog, and my doctor says that may negate your responsibilities without, if they didn't have a form, may negate your responsibilities under Iowa law, but it doesn't negate your responsibilities under federal law, right? So
Okay.
that's my point, is that, under federal law, you don't need to do the form, tenants don't need to do the form.
Okay.
And so that's where the confusion arises, right? Because the legislature and the governor signed a bill saying, all right, tenants need to do this. In this situation, hey, everybody's aggravated about these emotional support animals, and this is what we're gonna do. Tenants, you gotta do this form. Well, okay, fine, but you can't override federal law, which doesn't require a form. So anytime but you can, under state law and federal law, ask for backup documentation. Just make sure that when you do it, that you're not inquiring into the nature or
Right.
extent of their impairments or disability.
Okay.
Just keep it brief. And I've done a lot of these presentations in Iowa and in New Hampshire over a couple decades, and all I say is just say hey to the tenant, give me a doctor's note or whatever. One caveat there is that it doesn't have to be a doctor, and it doesn't have to be a psychiatrist. The law is very clear, it has to be a healthcare provider in a position to know of the person's impairments. Healthcare provider in a position to know the person's impairments. So
Okay.
every now and then you run by a case where, hey, I asked for backup documentation and their physician's assistant provided a letter. It wasn't a doctor, and I was like, you're still in, or an LNA or whatever, you're still, if you ask for backup documentation and it's a healthcare provider in a position to know, may even be like an LDAC. Let's say it's related to.
What about the online ones?
The question would be, are they in a position to know? And if you're going online, I think there's a pretty strong argument. If you're going online and no one really knows you, and they haven't really treated you, then they're not in a position to know. However, if you're going online and you're doing a bunch of telemedicine, and you've had a number of appointments, and they say, hey, I've had several appointments with this person, telemedicine and whatever, and it's my conclusion that they need an emotional support animal, well then that's different than just going online and putting in stuff in a website and getting a letter from whomever.
Right. And if I may, just one more question. As far as the liability, person X, you say, no problem. Bring your service animal or your emotional support animal. You do not charge a pet fee. You're saying we cannot require them to have renter's insurance. Is it the federal or the state that says that they have to have their vaccinations and rabies up to date?
Oh, that's case law throughout. That's case law throughout. Yeah, they gotta get their, they have to have their vaccinations and you can require that. Municipality in terms of licensing, some municipalities have a licensing, some people.
Do we have one, Chad?
No.
No?
You don't,
Okay, we
okay.
don't anymore.
Used to.
Used to.
Yeah.
I had to pay to.
So
My dog had a
some
doggy
do, some
tail.
don't, and then some have certain requirements to get the license, some don't. So, but you can definitely, say up to date on rabies and everything.
And you could put it in your lease. No, there's not any of those things. However, if their shots are only good for like, let's just say another 2 months, and they do not get them updated, and you give them a notice and say they have to be updated in, 30 days or something, and in that meantime, that dog bites the postmaster, delivery person, then what?
I mean, that's an interesting hypothetical, but I think, but it seems as though, that you would be taking all reasonable steps to try to deal with the
Yeah.
situation.
Because I've had people that are like, and I'm like, no problem, I love animals.
Yeah,
They bring their animal in. 60 days later, they don't have any vaccinations, they don't have any rabies updated, and you ask them, I'm just scared that something's gonna happen to the public, and then I'm gonna be responsible.
it's best to put that kind of stuff in your lease, but
Okay.
also if it's not in your lease and you have no pets and you're doing a reasonable accommodation, to say in writing, hey, I'm granting you a reasonable accommodation request to have an emotional support animal on the condition that you document to me that their rabies and other necessary vaccinations are up to date.
Okay.
You provide that documentation within
That would
45
only be
days
fair.
or whatever.
But
You can say that in writing.
regardless of whether their rabies and shots are up to date, if that dog bites somebody, is that the landlord whose pocket that falls in if there's a suit, or the person?
The city still has animal control ordinances, and so it's still gonna fall back on the animal's owner,
Oh,
right, to maintain control of their animal, so.
so that,
Typically in a dog bite
Protects us.
case, it's on the owner.
okay, that,
Quick.
The owner of the dog, not the owner of the dog.
Oh,
I have a couple
Yeah.
more quick questions.
Go for it.
Annette or Caitlin, one of the two. So, I was under the impression that if somebody has had an eviction, they can't get Section 8 or the voucher program. But you were saying a little bit ago that, is there a time frame or something?
My plan just updated, mine only goes back 3 years. I believe Katie's goes back 5.
So, is that just for non-payment or for any type of eviction? Any. So if somebody was evicted from a property 3 years ago and now is applying, they can still apply? Okay.
They can still
They-
qualify, but they
Qualify.
might not get approved.
Anybody
can apply.
Right,
Yeah,
right.
Anyone can apply.
Okay.
I tell all my landlords, I screen them for eligibility.
A
You
landlord
screen
can
them for
still,
suitability.
yeah, a landlord can still deny
Right.
because
Personal.
of an eviction. They can
Okay.
say, nope, they've got an eviction on the record.
Even if it's like almost 20 years back.
A landlord can do what they want with it, I mean.
But they can still get on the voucher program?
Yes,
Okay.
they just might not be qualified at that particular property, would have to find housing somewhere else.
Okay. And you were talking about housing authorities.
Mhm.
Is that different than landlord, or is that also inclusive of the landlord?
Burlington Low Rent Housing Authority is what I operate
that
under.
you?
That's
Oh,
our
okay.
umbrella. Yes, we do public housing and we do the housing choice voucher.
Yeah, because you had said in other housing authorities, and I didn't know what you meant.
Right.
Okay.
Like Fort Madison has their own,
Okay.
usually each municipality.
So
has
like
one.
my jurisdiction is, those 4 counties, but I don't cover Burlington.
Okay. Just 2 more quick ones. Ashley, the home energy audits that Alina does, is that for
Have you answered
rentals
that
also, or only for owners?
Renters can go in there and fill out the
Get a home energy audit,
Yes.
or you get like the thermostat and the light bulbs?
I
and
think
they
so,
can do
but I
that as
wanted
well.
to show you
Oh, okay, I thought that was just.
They just sent out an email today about the savers on the thermostats.
And James, just
Yes,
a
ma'am.
quick one for you. You said repairs had to be done within 60 days.
Correct, yes, ma'am.
So is there a leniency to that? Because I know that like when I've had like major plumbing issues, for example,
Right.
and the plumbers, I couldn't get anybody or my furnace guy, it took him a year and a half.
Right.
And I had one that worked, but
So we see issues. I would say a common one for us would say windows. Say second floor, the upstairs window does not meet the egress requirements of 5.7 feet. During the inspection process, we go up and the window does not meet the requirement. In that time frame, what generally we will do is if the property owner provides us with a paid invoice from the window company saying, hey, I bought these windows, they're on back order. I'm just using windows because that's
Yeah.
generally something that's generally on back order, especially in Burlington, being a lot of older historic homes. Window sizes vary quite a lot versus like kind of more of a standard build. We will generally at that point say, okay, we have this copy, we put it in that file. We will stay in contact with that property owner to say, hey, when these get put in, we do need to come back out, verify that they are in fact the correct window egress. And we can also look at the invoice and kind of see what you've ordered. If we can get the specs, you know, online or something. And at that point, we will schedule a re-inspection to come out and just verify that the windows have been repaired. Trying to think.
so there's some leniency there.
Yeah, I mean a furnace. I don't know.
Well, no, I was thinking more like a plumber, you know, or.
Right. I mean, how do I?
Making progress on it.
Right. I mean, it really depends on what it is. If it's something like a window that can kind of be an oddity in size, or you know, you're waiting on a contractor. Say you have, I don't know. Oh, okay. Here's a great one. Say we're in a unit, a single family or multifamily, and say the service size for the electrical is like 60 amps. What we do is then any service that is under 100 amps for the city of Burlington is required to have load calculations. Say you get the load calculations and they come back and they fail at that point. Say they're using, I believe it's 85%, and don't quote me, I have to look, but I believe it's 85% ampacity. At that point, those are required to be at minimum 100 amp services. They have to be installed at that point within a year. So say you had a 60 amp service on your house that failed load calcs. You have a year at that point to get that electrical service upgraded.
Okay,
With the city, so.
okay.
Quick question for, I'm not sure exactly who. If you are currently on a voucher program and your property gets sold to a different landlord who doesn't want to be a part of the voucher program, do you have any protections?
No.
Okay.
If you're mid-lease and mid-half contract, they have to accept and honor that
Right.
portion.
Okay. And then,
First year, yes,
Correct.
yes,
Yeah.
yes, okay.
okay. And then follow up for that, if that happens to you and whether or not you're on the voucher program, should you require your landlord to give you a new lease? Or does the current lease that you originally signed with a different landlord follow through?
Yeah.
New lease, new contract.
Okay. Is there a time frame in which, if the landlord does not provide you a new lease, you should do something as a tenant?
I mean, if they're on my program, call. And
Sure.
We'll make it, hey, you're a new owner, this is what tenant is.
Right, that's an expectation of being the landlord is, we can put a hold on your payment as well.
Okay.
And that usually motivates them to do what
I
they need
mean,
to do.
that's assuming they wanna have it as a rental, right? So
Correct.
if I wanna buy this place that's a rental, but I wanna live there and I don't wanna rent it, you can have those people move out, right?
If you're outside of that 1 year window, you gotta be outside of that 1 year window.
Right.
Right, so let's say that you bought the properties with, it's leased up, half contract lease with old owner, we'll call it old owner, for 1 year, and then you buy the property 3 months later, and then you're the new owner, you're stuck with that 1 year deal.
Okay, cause I was under the impression that any leases or obligations
Yeah.
for a new owner, they didn't have to, honor those.
They have to honor, they have to honor that for that 1 year period, for that lease. Now, if you, a lot of
Just
these
for
restrictions-
section
Section
eight?
8 one.
Well, even if, now that's section
How
8
about
for the
the
half.
non-section 8?
If you have a contract, you step into the shoes, you still have to honor that contract. So you can't just evict people with a 1-year lease.
Even if I'm gonna
Basically.
live in the property myself?
So if you come in and there's a lease, you just have to go buy the lease, right? You can say, I'm not gonna renew your lease.
But they can live out the rest of the lease.
Correct.
Even if there's an early termination clause?
The early termination clause, yeah, early termination clause would be different, potentially. But
Yeah, I don't know if I,
if you step,
Understand
the
that.
basic contract law is you step into the shoes of the actual contract. So, whatever that lease may be, the basic rule is you step into the shoes of that owner.
if the house is sold,
Even when the house is sold,
Oh my
you're stepping
gosh.
into the shoes
I did not know that.
with those existing
So
tenants.
as the tenant of a place that's being sold, if the old landlord, just before he sells it, writes you a new 1-year lease, the new landlord would have to
Adhere to
honor
that.
Yes,
to the
correct. Yep. Now, there could be all kinds of different provisions in that, but you,
But even if they're doing a 30-day non-renewal,
if you do a 30-day non-renewal of a lease, let's say the lease is expiring, and you do a 30-day, you can still do that. But if there's a new lease that's in operation, you have to honor the existing lease. You do a non-lease renewal at the end of that lease, of course.
Yeah, at the end, they can then put you out.
Yeah.
I did not know that.
Yep.
Always
Step into
remember
the shoes of, that's the fancy legal term.
Can
Step
you-
in the shoes.
Can you require, before you finalize that purchase, that the old owner give the tenants, notice?
Well, I mean, again, if they're under an existing lease, then,
It's a different contract.
yeah, it's
Not
a
with
different,
the Fire.
yeah, but you, again,
Just my opinion.
the basics of it are those, so, let's just use existing owner, whatever agreement they have with the tenant, that has to be honored, okay? So if you're stepping in the shoes of the new owner, you can't tell old owner, hey, you're just gonna randomly terminate a contract, because you can't. You can do a non-lease renewal. You could say, all right, we're coming up on the end of the lease during the pendency of this transaction. I would like you to issue non-lease renewals, so I don't have to do
But
it.
if there's still 4 months left, I have to wait 4 months
There's
before I
still 4 months left.
can move into a house I just bought.
Or you can buy it, because it's an opportunity to buy it, and then, in 3 months you issue the notice, right?
Okay, I didn't know that. I always thought that once you purchase a new property, that all agreements made by the previous owner are null and void.
No.
This is for, is it Ashley?
Yes.
Cause I have RTOs on all of my properties, and you were saying, I was just wondering, what's the rationality or what's the reason that you won't turn it back into my name if it's due to non-payment? And the reason I'm asking is, say for instance, XYZ got disconnected,
Right.
I missed your call or whatever, okay? And then the pipes burst because it's January.
Right.
Help me understand why, if I have an RTO and I've agreed that if something happens, please turn it back into my name. I'd rather have that than broken pipes.
I totally understand that. We will typically contact the landlord and give as much time as we possibly can. We'll send letters, we'll contact them by phone. Unfortunately, we can't assume or have the landlord assume responsibility for a property that they're not living at. Because if we did that, then you could have somebody living there for months, for years, and you would have utilities in your name, and you may not ever know about that unless you got a notification, unless you received a bill somehow. So
I was gonna say, how would you not bill?
It
Would you
would-
send it to the
it would
tenant's
continue to,
address?
it would continue to go to them. unless you had it set up where it's going to you, but it will never automatically go into your name for a non-pay. And the reason for that is we cannot assume technically that you are willing to take over responsibility for somebody else's electrical or gas usage. The only time that we would put it in your name is if they call in and they are moving out. I worked for Mid-American for 10 years, and I've worked for this utility company for 10 years. I don't know if I've ever seen a situation where we turned off the utilities in the winter and that there were damages. There are a lot of extreme things that we do, certified letters that we send out, contacting family and friends or anybody that have on the accounts or anybody that's contacted us. There's a lot of work that goes into that because that is the last thing that we want to have happen. But we just, unfortunately, we're not able to say if we see a disconnect notice on an account. Otherwise, we would have landlords everywhere responsible for billing for other people for their tenants where they don't want that. So that agreement just is not available for it to go into your name automatically, only if somebody moves out.
Sorry, that happened in an upstairs and ended up, the pipes burst and flooded the entire place and down.
I am so sorry that happened.
I was just wondering, I was like, I have an RTO, I have an RTO.
Yeah, and the leave bond agreements for disconnect for non-pay are just not available. Not
Okay.
available for us to even offer, and that's something that probably the utility board would not even allow us to offer.
Oh, really?
Yeah,
Okay.
just for those reasons. Did you?
So just last week, I had a Alliant call me about a tenant who owed and they possible disconnect. And they asked me if I want that to go back into my name.
They may ask you if you want it to go into your name and assume responsibility, but they won't automatically put it in your name.
So they may
without
ask.
having a conversation.
I was out of the
Oh,
happened
yeah.
something, you know.
All right, so we are a little over time. Are there any last minute questions from anyone in the audience?
I just want to say thank you. You guys have been a wealth of information. Thank you.
Yes. Any last minute comments from our panel? Okay. Yes. Thank you everyone for joining us either in person or on Facebook. This has all been recorded, so if you want to go back and rewatch anything, it will all be on the United Way of Southeast Iowa's Facebook page. Thank you everybody. There's tons of resources as you walk out the door, so feel free, and if you'd like to come and chat individually, I'm sure the panel would allow that as well.
Thank you so much, you guys. That was wonderful. I was the one